Now, you did not disclose in any of the designations or your report that you had met with and had dinner and drinks with Mr. Depp, did you?
I'm sorry, can you repeat that one more time?
Yes,
That
you did
confused
not
me.
disclose in any of the designations or in your report that you had dinner and drinks with Mr. Depp, correct?
I did not disclose that I was interviewed by the legal team, no.
I asked a different question. Are you trying to resist that you didn't have dinner with Mr. Depp and drinks?
I'm not trying to resist that, but it's not quite right.
You did have dinner with Mr. Depp, did you not?
I did, with
And
his
you had
legal
drinks
team
with
and
Mr. Depp, did you not?
And what?
You had drinks with Mr. Depp, did you not?
Drinks were served. This was over 2 years ago. I may have had a drink with dinner, yes.
In fact, you thought you had a mule something, right?
Possibly.
Yes, okay. And you didn't disclose that you had met with Mr. Depp, Mr. Waldman, Mr. Chu, and Ms. Vasquez at Mr. Depp's house for 3 to 4 hours and had dinner and drinks, correct?
I did not disclose that. It's not significant to the report.
You don't think that's significant, correct?
I don't.
Okay. But you've never been asked to meet with a client in his counsel before being retained as an expert, either before or after, have you?
No.
And you justified that it was okay in this case because it was a high-profile case.
That's not quite right. I justified it in this case. Actually, I sought consultation about it. First of all, the person who had retained his attorneys was unable to come to my office with his attorneys. And yes, this is a very visible case. It's been going on a very long time. And I understood that there would be a need to interview me and make an informed decision about my qualifications.
Can you look at page 240, please? Line 3 is my question. Would you agree it's highly irregular to meet with the subject in a litigation? And your answer on that occasion was, I would not say it's highly irregular. I would say it's not something that I would typically do. However, I had not yet been retained on the case. This was a large, high-profile case, and I understood that I believed that it was appropriate for a person retaining me with such a high profile to meet me, to be able to vet me, essentially with the attorneys present prior to retaining me on his case. Do you recall that?
Yes.
That's what you said under oath, correct?
Yes.
And then I said, have you ever done that before? And you said, no. Correct?
Correct.
And then I said, have you ever done it since? And you said, no. Correct?
Correct.
Okay. Now, would you agree that if you did not find something that would be in favor of Mr. Depp and negative to Ms. Heard, that you wouldn't be an expert in this case? That I can bring you into court if you're going to say that Ms. Heard is right and Mr. Depp is wrong, correct?
So as a forensic psychologist, my obligation is to the court, is to the fact finder. I present science regardless of what that science may be. Now, when I take a case, my retainer agreement is explicit about that, and I discuss that with the attorneys.
I'm asking you a question. I'd like you to try to answer my
Okay.
question. You understand that if you found favorably to Ms. Heard and negatively to Mr. Depp, you wouldn't be here, right? You wouldn't be testifying.
Objection speculative.
No, okay, sorry.
Hold on. The objection is speculation.
That's not speculation.
No, I'll sustain the objection if you want to ask.
Okay. If it goes to bias, Your Honor.
I sustain the objection. Next question.
Okay, all right. You were, in fact, so excited about being involved in this case